We can quite clearly establish what happened on the 23rd of December 2011. Some minority shareholders of Ventbunkers gathered under the lead of the rather famous lawyer Martin Squeps. Even though no such meeting had been convoked by the legitimate management board of Ventbunkers, this criminal group alleged that this was a shareholders meeting. The real shareholders meeting was convoked for and took place on December 20, 2011. At that meeting, more than 70% of the real legitimate shareholders of Ventbunkers were represented, and they have reconfirmed the existing supervisory board of the company. On the 23rd of December, there were less than 30% of the shareholders represented. The falsification which Quebs did was in two aspects. First, Quebs held a meeting which was never convoked by Ventbunkers management as a shareholders meeting. Second, he accepted and made participate at the meeting two shareholder companies which in reality were never ever shareholders of AS Ventbunkers, namely the two companies Steropus Limited and Geitjes Limited. So in the result, the situation was as follows. On a date on which no shareholders meeting was convoked, two companies, which are not shareholders of Ventbunkers, reunited with a minority group of shareholders, and together they alleged that this was a real shareholders meeting. The falsified documents were signed by Quebs and submitted finally to the Register of Enterprises by an associate of Quebs law firm. On the face of the papers, for the Register of Enterprises, everything may have looked normal. Therefore, the registration was made. Obviously, I think it is too simple to submit false documents to the Register of Enterprises and effect changes in the management of a company. The question who stands behind this brutal falsification can be easily answered. If you look at the list of the shareholders who allegedly participated at the false meeting, it becomes very clear who is responsible. Obviously, everything was orchestrated by the famous Martin Quebs, who probably is the most famous and most skillful falsifier of shareholders meetings in Latvia. Together with him, the following companies participated. First, the company Kement was represented by Jānis Berkis. This company is owned by the father of Jānis Berkis, who by coincidence was then elected to become the chairman of the supervisory board of Ventbunkers. Also present were the company Topmar Baltic Investments, which is beneficially owned by Oleg Stepanov. Stepanov's puppet, Alexei Avad, was elected to the supervisory board. The two companies who are not shareholders, I repeat this again, who were and are not shareholders of Ventbunkers, Steropus and Geitjes Limited, were represented by a lawyer Jānis Junkers, who was also elected to the supervisory board. These companies are beneficially owned by Igor Skoks and Gennady Shevtsovs. Now, the most intriguing point was that the company Optima Management was also represented at this meeting by Gatis Klimas, who, again, was elected to the supervisory board. Quite funnily, Optima Management also participated at the legitimate shareholders meeting of December 20. It is rather well known that Optima Management is close to Lemberg's family. And then, last but not least, Anris Lembergs and his sister Liga Lemberga also were represented at the shareholders meeting. From this, it becomes clear that this brutal falsification was also supported and accepted by the Lembergs family. There is a quite well-founded rumor that the participation of the Lembergs family was managed and organized by Edgar Janssons, a former or long-time associate of Lembergs. There may be several reasons. First of all, there are a few very important court cases ahead in the beginning of this year 2012. Probably the falsifiers wanted to be able to represent Ventbunkers in court in the case against Litasco, which takes place on January 3. It is well known that the whole dispute with Litasco is only related to the defrauding of income from Ventbunkers by exactly the same minority shareholders which have falsified the shareholders meeting, excluded the Lembergs family. Additionally, they probably planned to implement some new criminal schemes to steal additional money from Ventbunkers by signing some bogus agreements just before the year end, similarly as was done at the end of 2009. Ventbunkers has submitted its complaint to the Register of Enterprises and to the criminal investigation authorities. Additionally, the Ventbunkers management made certain precautions. As the threat of falsifications was apparent since August, some reserve meetings had been convoked, and the shareholders meeting on December 26, 2011 decided that certain corrections had to be made, which were registered in the Register of Enterprises. Unfortunately, it is too simple. A falsifier simply falsifies a shareholders meeting which has never been convoked and at which the majority of shareholders needs not even to be present. But then, on the paper, the person making the minutes wrongly states the opposite, namely that the shareholders meeting was convoked, and number two, that the majority of shareholders were present. On the face, such a document may look quite genuine. Unfortunately, the Register of Enterprises refuses to verify the documents submitted to it, even if it is expressly warned. The Register of Enterprises acts like a blind machine and registers any documents, be they false or be they not false, which fulfill the formal requirements which have been defined by the register. Even if the register receives a substantiated warning by the legitimate shareholders, the register does not exercise any control whether the documents are genuine or false. This is obviously an invitation for criminal minds to make such falsifications, and they may even be successful with the registration, as the example of Ventbunkers has shown. I believe the law must be changed in Latvia. In this area, the Latvian legislation has a major defect. It allows the registration of false documents even if the register is warned. Most countries in Western Europe have a special system that the legitimate shareholder who becomes aware of attempts of some criminal activities to take over control over a company can warn the register. If the register receives such a warning, then the registration is stopped and the matter is referred to a decision by the civil courts. These systems work pretty normal in Western Europe. Latvia, however, has nothing to protect the legitimate shareholders. This defect in Latvian legislation must be corrected. It is a must for a functioning economy.